Welcome back. We have joining us the Labour Commissioner, Ivan Williams, and the Deputy Labour Commissioner, Paulette Wagner. Good morning.
Good morning.
Hi, good morning.
All right. Thank you for being here this morning. So, our official conversation for today, and we want to get this part done with because I know there are other issues that will come up, is talking about what our labor laws say when it comes to hurricane threats. This is something, every time there is a hurricane threat, the media especially, we get called from employees all over the country expressing concerns and challenges they're having. So let's jump right into that particular topic so people can be able to understand what our laws actually say.
Well, Marlene and Kevin, radio listeners, the Principal Labour Act, as we refer to it, which is Chapter 297, makes provisions, I think it's under Section 32, which emanates from a general duty that the employer must provide work. But it also goes on to say that in circumstances where the contract could be, and I think in law, frustrated, and that could come as a result of many factors. And for instance, if there is a calamity or a natural disaster on which hurricane falls in, and generally an act of God, which is beyond the control of either parties, the employer and the worker. In such situations, then the contract can be deemed to be frustrated and is temporarily suspended. In other words, the parties still have their employment relations, but albeit circumstances beyond their control. Now, that's what happens. In addition to that, there is also provision with respect to, and I want to bring in Convention 29 here in respect to forced labor, which means that you cannot force people to work in certain situations.
Convention 29 of?
Convention 29 of the ILO, the International Labour Organization. And it's also mirrored in our legislation too, in I think Section 157 of the same Labour Act, in respect to compulsory or forced labor. And so you have these two competing interests where you cannot force me to work during those situations, and the employer is not forced to provide work. Okay? However, there's also, you have to look at it in respect to the law relating to emergency, national emergency, which is the disaster preparedness and response legislation, which makes provisions for the establishment of national emergency management operations, setting in place certain disaster alerts mechanisms, and giving guidance to the public. And you know that national emergency takes precedent over other laws or rights that exist, because evidently it's a state of emergency. And so, in many respects, all of us are responsible to take guidance from the instructions and the alerts and the advisories coming out of NEMO. That is a fundamental principle. And so, for example, NEMO would say to the general public, it is time for everybody to make sure that they are safe, to protect their lives and protect property. It is at that point that we would then feel that the contract then is really frustrated. And for that time period, then both parties can sever the relationship. And because the employer, because of the circumstance, cannot provide work, then evidently there will be a window in which a discussion must take place whether in fact wages would be paid. Because no service and so on. But basically, to sum it up, is that we follow guidance from NEMO. What we encourage, and I think it is very clear in the disaster preparedness and response legislation, that we must have in place policies and plans. So you can't wait.
Individual companies.
Individual companies must have policies and plans which sets out the relationship and what takes place at that point in time. Because it is hard to say specific, given the circumstance of the company and the nature of service that it provides, what will happen. And so we advocate for plans, jointly agreed to, so that if the employer requires the employee to stay within a time period, even stay and weather the storm, that is agreed to. So it's a balancing act.
Is it an oral contract, or does it have to be something written?
It can be
Or
oral
both are valid?
Both are valid, oral or written.
Okay. Now let me.
And so basically what I'm trying to say is that
You
it's
should
a,
work it out
it's
with
a
your
fluid
employer.
situation where the parties engage
Yeah.
and beforehand make arrangement what will happen when the event happens. And so in terms of payment and all of that too can be worked out.
Now, this is ideal
what-
in terms of how companies would function. And there are companies who do go this extra mile in terms of preparation. But a lot of times, if tomorrow there's a storm that may potentially hit Belize in 3 days, nobody's gotten around to a hurricane plan yet. One of the complaints you'd normally hear is that people are not being given time off to go prepare themselves, their families, or secure their property. And that is allowed for under within a state of emergency. Is that the case? What does an employee do? What is your recommendation when that happens?
My recommendation is that if they don't have a plan, then they ought to do something at that point in time to have a discussion.
Yeah.
Because it is only fair that if an employee does not live in the immediate environment, they may need to go and secure, let's say they are prepared to stay back with the employer.
Yeah.
They need to first take care of their own family and property. And so at that time, they should engage in a discussion without force, mutually agreed as to what is going to happen.
Yeah.
Usually, the time depends on, it has to be reasonable
Yeah.
time off because it depends on where you're going and your location.
So if I live in San Pedro and I have to go there to secure,
Right.
I'd obviously be given more than an hour to go and take care of that.
So we expect the parties not to be unreasonable
Yeah.
in the circumstances and
But
to
you-
more or less,
But you do accept
Yeah.
that employer-employee relationship is not an equal footing sort of relationship. The employer is surely in a more powerful position than the employee.
yes.
And so in terms of, is there anything in terms of an actual piece of legislation that actually tries to balance this out without leaving it to the parties and the wildness of that?
Well, it will fall under one of the service that we provide, which is if for some reason one side uses the opportunity, because I want to do it on both sides. If the
Yes.
employee leaves too early, the employee is also,
Or without warning.
or without warning, is also in breach of the terms. And similarly, if the employer unreasonably keep the person there, there's also the possibility that they're acting not in good faith in terms of the contractual obligations. Either side can make a report to us and we will come in and investigate it so that we can see whether there's a fair treatment, and if it is a case where the person is being terminated because of that, then clearly we can say it wasn't good and sufficient cause, and to advocate for the person to be reinstated, or at least not treated to be dismissed, but to get all benefits and rights ensued on both sides. And so while the law, we need to work more on the laws. You know, it's difficult to revise laws in Belize, because we subscribed again to a very important convention of the ILO, which is Convention 144, which says that the Labor Department or the government alone cannot pass legislation. We must first engage our social partners or tripartite partners. We have to engage the private sector and the labor. And we do that through the Belize Chamber of Commerce and Industry, which is the legal representative of employers' interests, and the National Trade Union Congress. And there has to be a discussion. And there has to be a kind of trade-off, a kind of negotiation as to how the law. Although we are guided by some conventions that we sign, that we can say it's a matter of complying with a convention. But I can tell you, yes, so we will have to go through that process.
Yeah.
You remember in 2011, we made some small amendments to the
Yes.
labor law. That took us 4 years
Wow.
on the table negotiating with the parties, and so on. So,
Are there discussions going on now between those two bodies?
yes.
And how close are we to another amendment?
Well, you will recall that the primary mechanism is the Labor Advisory Board, which the Honorable Hugo Pat inaugurated just a year and about 4 months now. And so we moved swiftly, and they're engaged, tripartite partners. We are looking at updating our laws in line with the ILO Convention, which relates firstly to child labor. And then we look at discrimination in employment with particular emphasis on women. And so as we speak, there is feedback coming from the stakeholders in respect of their position with respect to amending the laws or bringing them in line in respect to child labor. So after that, we will then move to the next stage, which means bring it to the attention of the minister. You know, that long process to
What's
cabinet.
the delay in getting these amendments passed through? Where does it take the longest time?
To come to an agreement
Okay.
by both sides,
Yeah.
or all three sides, the
Yeah.
government, employers, and workers. And then to get the general will to move the process.
Yeah.
Okay.
Now,
Yes. So in a nutshell, that's what happened in case of emergency.
so let me just say this in direct action to people. The first step is, if there has not been an agreed upon hurricane protocol, which means when there's a warning, you do X, Y, and Z, or you're allowed X, Y, and Z. If there's nothing agreed upon, approach your supervisor, employer, and say, I need to go because of X, Y, Z. You are entitled to that time, sufficient time as well, but you must make the approach or have the conversation first. That's what you're saying.
Exactly.
And then you're given that reasonable time. And if they say no, not now, maybe later, or the storm not to come. We hear that one too.
Well, that is why we feel that if they are put in a situation where they feel that their interest is not being served, and they leave, we will have to look at that to see whether the person acts in a manner which is consistent with their rights and protect them.
Yeah. So you should be given that time off. Now, after a disaster as well, let's say I have to deal with, I was a victim of Hurricane Earl. I live in Ladyville, and my entire property was damaged. What's the allotment of time in being able to have some time to take care of what's happening there before I go back to work? Because Belize City, people could have functioned the following day, minus electricity, but they could have.
Well, we'll have to use the reasonableness or the reasonable man test. There's no, the law doesn't specify a specific time, but I guess again the communication and dialogue. You don't expect an employee could return in the circumstances where their situation is still in a situation where they need to take care of that first.
Okay.
So while there isn't a specific time, there has to be again communication, informing. As a matter of fact, from the beginning of the conversation in terms of the employment, there should be certain things known. You know,
Ideally,
where the person works, where the person lives. So there's certain things beforehand, or you can ask. But to answer your question, Marlene, there isn't any specific time frame, but it depends on the circumstances.
So let me just get one thing in here, because what I'm hearing from you very clearly.
It would be deemed that the contract is frustrated to that period.
Because it is a state of emergency. But what I'm hearing from you very clearly, and I want to pull it out so we can ensure if this is what you're meaning. There must be proof of some kind of communication to your employer. In other words, we can't feel entitled to leave or not show up for work to secure a home. Or you can't feel entitled to not show up to work after the disaster. You must have some. So if I bring a challenge forward later, one of the first things you'll probably ask is, did I communicate it to my employer? Is that what I'm hearing?
Yes.
Yeah. Okay.
But the other thing was that I know you have a very competent staff. Practicing law, that's one of the first things I tell people coming with complaints. That you guys have, you had Miss Peters.
Yes.
Was there, and you have Mr. Palacio, is he still there?
Yes.
And
Miss Peters recently died.
I know, she
bless
passed
her
away.
head,
But she was excellent.
Yeah.
So you can call the labor department and say, may I speak to a labor officer? And ask your questions.
Yes.
And I find that they're very, I don't know the training that you've given them, but they seem to be very knowledgeable. Could you talk to us about the complement of staff that you have there to be able to assist people with questions that they might have?
Well, I'll turn it over to Ms. Paulette. Ms. Paulette is...
I'm big up the public servants thing too, because we work hard sometimes.
We have 10 offices countrywide in all the districts. I'm not going to name them. Corozal, Orinjo. Okay. And then each office has a complement of one labor officer, one employment officer, because we do promote employment service as well. And so each office has an two technical persons, a labor officer and an employment officer. Then we have like secretary and that type of support as well. And so a total of 10 stations. In Belize, we have 4 officers, 4 labor officers and 2 employment. In Belmopan, we have 3 and 1. So we totally have like 14 labor officers right now and 9 employment officers. So that's the kind of support we're working with.
Yeah.
And what kind of training?
Well, they go through an in-service training, where as soon as you come to the job,
You're introduced.
you're introduced. It's a 3 weeks intensive
2.
training where
Only
you,
3 weeks?
Only
yeah,
2
just
weeks.
2 or 3 weeks.
We said 2 weeks because it's just to introduce. You need to tell people this is your job description and these are your tools.
Yeah.
I have been accused that that's not enough. So I told the last officer that was complaining, I said, young lady, we can't train you for 6 months. You come here with certain skill base, and once we introduce you to what we expect from you, the learning will come with practice. We're supposed to be team players, and you could depend on your support colleagues for support. That's what we expect. When we put you out there after 2 weeks of trying to show you your tools and
But Ms. Wagner, I'm telling you, they're doing extremely well.
but that's how we work. I encourage
Because-
team play.
Because you are a trained
well, Kevin, yes. Since I came back from studies,
You're a trained attorney.
I'm a trained attorney. I have done substantial work in the department in setting up policies, procedures, and we have been having weekly, or not weekly, monthly meetings in which staff bring their situations and we trash it out. And there's also a network where they can liaise on each other's persons who know more than others. There's a communication going on. And for the most part, we walk them through and we do our best in-service training. And many of them come though at the capacity of a first degree. So they are, you know, the standard is very high.
You know, and
it's one of those departments that pay people well too.
And I think, you know, echoing what Kevin
Relative
is
to the
saying,
public
people
service.
are comfortable calling in to, for the most part, comfortable calling in and asking their questions regarding the labor law. But my question really is, do you have a methodology for public awareness? Because, you know, not everyone has the confidence or the assertiveness to call and ask. A lot of people suffer in silence or suffer believing that they're being experiencing some injustice and never take the initiative. So what do you do to ensure that there is a wider public knowledge about the labor laws that govern employees?
Key document that we disseminate, along with a shorter version which is called a quick facts. And then these things are online too, so you could read them.
Do you use social media? Do you put information on social media? Do you get?
Yes, we started that, and we are now having CETO along with us. So we'll be doing a lot of
What's CETO?
the
Information.
government
Information
technology service, right? And we will be doing more of that in terms of the Facebook and social media.
Because people have lots of questions.
But we also have functions. Every function, like for example, every Labor Day, we go countrywide and have open day.
What's your Facebook page, sorry? What's the Facebook page?
The Ministry of Labor.
Okay.
That work.
So when you hear perhaps regular complaints coming in about something, you'll put out information online so people can maybe know without having to ask?
Well, that's what we have a public relations officer in the name of Miss Jenny Neal. She's currently on vacation, but that's her role. She put out
Maternity leave.
maternity leave. Sorry.
Very important, different kind of leave.
Which there's a pamphlet for too, in case you need to know.
And that's her primary responsibility.
Yeah.
So she feeds into the social media. She feeds into the government information service.
You have to.
And so there is information out there.
You know, we hear all the time from people that yes, we need to take the initiative as employees to understand the labor laws. But I will be the first to say, and we hear it all the time, the language is not necessarily what your average person can understand. What we know about should and must, two different things compared to what a lawyer thinks of should and must. But that's why you were saying.
This quick facts, it's the same thing that's in the book, but it's in brief statements, easy read. And this is what we normally give to workers. We would give the book to an employer. It's the same basic information, but this is simpler language. And one thing we didn't say, I didn't hear it, in addition to people coming to us, we do outreach.
Okay.
Any business could contact us and ask that a labor officer come in and explain these things to their staff. Because we believe as labor that if
Do you
you're
get
employed,
requests like that?
yes, regular. And so we always send a labor officer here and there, and then we want to keep those people employed. That's the
Yeah.
thing. We are worried about the unemployed, but we want to keep the employed, so
Yeah.
we respond.
So what's the
respond.
main question or concern that people reach out to the
This is
office for?
pamphlet.
Well,
No, but what question do they ask regarding labor?
we also have the
Number one?
situation where
Notice,
Yeah.
vacation,
we always have the situation.
severance.
We also have a situation where we protect persons who come to file a complaint.
Yes.
In the past, people used to say, I don't want to go to labor because I don't want the employer to see me going there. We put in a provision in there to say that it would be unfair or unlawful for you to terminate a person who has come to the department seeking
Yeah.
advice. Okay, similar, because the employers...
So when you request information about where they're working, right? If you
Yes.
have a question or concern.
Yes.
And that's confidential
No,
information.
that's not priority though, because if people are uncomfortable, we just give the advice.
Okay.
We don't pressure them to say who you are and where you're coming from.
Okay.
We want to just answer the questions.
Yeah, one of the things-
But in addition to that, though, it's confidential because for you to give the advice first, you have to know certain things. So you do have to ask, and that's why I hear sometimes you call the labor department and they says people give different advice. But remember, if you give the same facts, because if you change the factual base, then you will get a different answer.
Yeah.
But generally, yes, we are all trained to make sure that we focus on it. And first of all, we need to know what area you work.
Yeah.
Because if you're under the Labor Act, for example,
You fall
there's
under
a different advice.
category of workers.
If you have a collective bargaining agreement, because Belize is one of those countries who signed on to freedom of association and the right to collective bargain. So we do have some CBAs, collective bargains out there. Then if you're a government employee, whether you're a government workers regulation or whether you're a public service, or even if you're a teacher under the Education and Training Act. So the advice has to be given relative to the category of worker and the terms governing the document governing.
I don't want us to go past this because I find this to be extremely important for persons out there who are having difficulty. Because I don't want to talk necessarily about the theory of it.
Yeah.
Because people have actual problems, specific problems. But the final thing generally that I would like you to speak about is the fact that the labor officers actually can take your case to court for you.
Yes.
Could you talk to us about that service? So if I'm there and I say, man, I can't go up against this very rich employer, but I know I get a chance. What can the labor department do practically on the ground for that person?
Well, yes, we can.
If they have a case.
Yes, we can go to court, Kevin, but we don't use that as the first resort.
And we've seen some cases go before the court for people with...
First, we carry out an investigation to understand where the rights and responsibilities on both sides are. Actually, there's a process where you come in and for example, if it's a case where you're terminated, then that's easier because you can easily access the employer, the relationship have ended. If it's a case where you're still employed, we have to treat it
Manage it differently.
differently. But basically, you go through that investigation, and at some point, the labor officer will say, I believe that there's enough basis to make a decision in favor of one side, either the employer or the worker.
Yeah.
Takes a position. In some regards, we try to employ what we call mediation conciliation services, because not everything we want to take to court, certain things can be done. And labor mediation has been with us forever. That's one of the services that we provide. Just like the court now is moving towards court mediation.
Yeah.
Well, labor mediation have been around for donkey years.
Yeah.
And then where we cannot find a solution, then we go to the court.
Yeah.
And the labor officer is empowered to take that matter and represent the employee in that regard. And that's how it plays out. For some time now, we have been able to impress on the the legal system or the judiciary to treat labor cases, because we're trying not to get up in the queue of the disputes or the line of cases, particularly related to civil matters. And so for the most part, we have been treated like a kind of revenue type situation.
Yeah.
And so that have elevated most of our cases. So they're pretty much
speed it up.
Speed up, yeah.
But
speed
let
process. So yes, labor officers are empowered to But first, go through that process that the employer is made clear as to why the officer has made the decision. It's not just taking one side, but ensuring that the proper process has been followed.
Let me ask, because what is the and I'm asking about proactiveness from your organization, because it is something that people really do need information on. But let's give an example. Let's say you get frequent complaints, concerns from one particular institution. You know, several people who work at one supermarket, different persons keep on calling. Do you then reach out to the entity itself and investigate what is going on, because I keep on hearing multiple concerns?
Yeah, once we get 2 or 3 of the same kind of thing, that to me raises it to the need to do an investigation.
Okay.
Go in and engage the employer, find out what is going on, because we go in as a friendly person, because we want to advise both parties.
Yeah.
We don't want things to get into the, like I like to tell them, media. We want to see if we could fix the situation before it gets noisy.
Yeah, yeah. Or social media, because now they just blast something online,
So
and that
we
is
respond
that.
after like 3 complaints.
Yeah.
For example, Marlene, I think not too long ago we convened a meeting with all the employers who employ security officers, because we were having some issues with respect to an understanding of the shift work
Yes.
law. And so, for example, we call in the employers and explain to them and go through and making sure that they are compliant. And where they're not compliant, we serve notice on them to become compliant. So it is where we get these concerns.
Yeah.
But generally, one of the main things that we get is the application of the notice pay
Okay.
or payment in lieu of notice. That's a common complaint many times, because you know that is one of the main forms how a contract is terminated,
Okay.
by either side giving notice. Okay? And the law is very specific. For example, in notice, the notice must be given. There is a schedule.
Yes. How much time you
how
must
much
be
time-
allowed to work,
Right. And
or you must work, I should
no,
say.
the number of notice to be given
Yeah.
to terminate
Yeah.
the employment
Yeah.
contract ranges from 1 week to 8 weeks.
Yeah.
But it is also specific that the notice must commence on the first work day of the next pay period. Meaning that even if I talk to you and says, look, I'm terminating your services, it doesn't immediately commence. It will commence on the first pay period. And quite often people make mistakes. And so we find that the notice was not adequately given and they're off, and sometimes we have to then make up the rest in terms of payment.
Oh, that's interesting.
There's a
I didn't know
specific-
that.
Yeah, specific period when notice was given.
So, like, if
and a
it's in the
timing.
middle of a cycle, maybe like the 3rd of a month, it would either be the 15th or the start of the following
Start
month
of the
that
following
your
month.
that your weeks
Right. Right.
of notice unfolds.
Right. And they'll also make provisions to payment in lieu of notice. So,
Yeah.
because we quite often we're seeing situations where employers feel that to have a person wrong on notice might not be very,
Yeah, sometimes
the relationship might not be well, and maybe there might be no
they
productivity.
prefer to have them out.
Right. So there is also payment
Yeah.
in lieu. Those are some of the issues, along with several, like, and maybe Paulette can highlight some of the other areas, or maybe you can.
I wanted
raise-
to talk about the differentiation in workers, because sometimes there's casual worker, there's shift work, and I think sometimes people need to understand where they fall within these categories. Let's start with casual workers. What is a casual worker?
Casual.
A casual worker is a worker who, basically, the law provides for a maximum of 6 days per week. Okay? And a 45-hour premise on a 45-hour work week. Of course, you can negotiate for less. You can say, well, I'm only working 2 or 3 days per week. So your week would be a 2-day, 3-day week. That's what we refer to as casual, who are
Okay.
not working the maximum hours required by law. And what happens is that translates into your benefits.
Oh,
For
okay.
example, a casual worker who is working a year for that casual worker for the purposes of severance will be 180 days rather than the 254 work days. So and again, for example, for sickness or for maternity is 150 and so on, 150 days. So the casual speaks to your entitlement relative to that benefit that you would get. And so you have to meet those requirements.
Okay.
For example, if you look at maternity, and I like to compare that with the Social Security, and I can't speak for them, but their provisions, for example, would say you have to be in employment for a year. And in some cases, many people who have been working and paying Social Security would qualify, but there are instances when people just commence work and then becomes pregnant or is employed pregnant. And the labor law, for example, talks about 150 days, which is about 5 months. So there are instances when you may not be qualified under Social Security, but you will be qualified under labor law. And then again, the casual nature comes. In this case, you would be
so
paid.
So how does that work? If I can get time off for maternity leave from my employer, but not Social Security benefits,
then the employer pays the full 14 weeks, where you're not qualified under Social Security.
Wow, I did not.
And
know
where
that.
you're qualified under Social Security, you and I know that Social Security pays 80% of your insurable earnings.
Yeah.
In other words, there's a band. It's not 80% of your wage.
Yeah, you don't
And so
actually get your full.
But the Convention 183 and our laws, the labor law, talks about full pay.
Yeah.
A worker is entitled to full pay. So there's a sharing in terms of the payment. So much by Social Security, so much by the employer, equal to full pay.
Where do you?
So,
go ahead.
yes, go ahead. No.
I was going to say, where do you find other misunderstandings in the law? I see highlighted in your
Yes.
quick facts an explanation of oral contracts. In this day and age, I think people should try to get something written as best as you can. But what qualifies as an oral contract?
Well, the law doesn't make a distinction. The contract, oral or written, is recognized by the law. The challenge that we have with oral contracts is that when you come to enforcement, it is a bit more challenging to
because then it comes he says, she said, right?
He says, she says. And we have to employ now looking at your records for guidance, or circumstances, or persons who go attest, and so on and so on. So most of the contracts that we see are oral. And they are for indefinite period, because a contract can be definite or indefinite, meaning you can clearly have a written contract for a specific period. But most of the contracts that I know of are oral, and they are indefinite, meaning that they will continue as long as the parties in the relationship continues. But yes, it is a little bit more challenging to enforce oral contracts other than written contracts. What we do though is that we encourage at the workplace to have policies and procedures in place. And by policy, I don't need a big thick book about policies. You can simply write a memo and stick it there, and as long as it is in line and not less favorable than the law.
Yeah.
And these things help to guide the relationship in an oral contract. So you have a combination of oral contract, but certain policies and procedures that are standard, which helps to enforce the arrangement.
Before you go on, I know we're quickly running out of time. I know a frequent one is, what are the rights of a person? Do I have a right to tell my employer he can't fire me? And what happens if he does fire me?
Well, I don't think you have a right to tell your employer he can't fire you. But what happens is that you have different forms of termination.
Yeah.
Okay? You have termination where it could be for various reasons. Redundancy, for example, where the post no longer exists, or some supervening event in terms of modernizing or automation and whatnot. There's a clear procedure there. You have to inform and you have to take steps. We recently made some amendments that the Labor Department needs to be involved to make sure that the redundancy procedures are followed. But we have situations which we call dismissal, which is a form of termination, but it is termination with good and sufficient cause, meaning that the employee has misconducted or did something wrong that is inconsistent, and that depends too on the level, because you can have things that can be misconduct and you have things that can be gross misconduct. As a matter of fact, if it is gross misconduct, you can have what we call summary dismissal, which means dismissal on the spot. Of course, it has to be something very serious and maybe have some effect on the employer's business and its loss of revenue and so on. But to answer your question, Kevin, yes, just like every relationship, it can come to an end. And that can come through notice, or it can come by an action done by either side. Either side have done something. Because on the other hand, too, you also have the employee who can abandon the service and claim constructive dismissal, meaning the actions done by the employer has made it unreasonable for the relationship to continue. So there are various forms of this termination or the end of the contract. Notice, act by either side, dismissal for good and sufficient cause. There are variations of situations in which the contract can come to an end.
Well, there seems to be so much more that we can talk to you about, and we got to schedule another one just to tackle these questions. No, I'm serious. There are a lot of issues I know that we need to give clarity. We talk about overtime. We talk about the same maternity leave, sick leave. There are tons of things we can touch on, but we really appreciate you coming in. That's why I tackled the hurricane first. I knew this was going to happen. Yeah, we barely went into it, but we are out of time, and we hope that we can have you back. One of the things we're looking at are many new employees going into the workplace, first-time workers who may not know, and we'll talk about some of the basics. So thank you so much. We appreciate it.
You are welcome.
All right. We're going to go ahead and take a break, and when we come back, we'll be finding out about the June promotions from Digicel.